to another edition of the Dirty Verdict Podcast. I'm one of your hosts, Peter Taaffe.
I'm the only other host, Bill Ogden.
And where's the third host? Hello.
I didn't even know we had one.
No third host. So instead, we've got all-star group with us, former guest and second highest views on Instagram, Will Moye. Thanks for joining us, Will.
You bet. Glad to be back.
And another guest who we recorded with earlier is Herrick Sovany. Thanks for joining us, Herrick.
Our favorite Frenchman.
That's right, dual. So I commend the prior episode or whenever it was that Will and Herrick were on because it was jam-packed with info of varying degrees. I think to me, I think to Bill, probate, med-mal for Herrick was very interesting. For Will, his trial and the insurance coverage issues that I will continue to pub Will for as someone that if you have some questions about insurance and you were on the plaintiff space, you should call him among other reasons, but that's definitely one that I think Will's got some real helpful info.
I found Herrick to be extremely informational and I learned a lot. Will was just boasting and that's somewhat unbecoming a gentleman, so we'll just leave it there.
I think he has so many views because as I think I warned on the first one, his mouth and brain work so fast that you have to watch the thing 10 times to figure out.
So together, we can make a baby that looks like Will because your brain is working quicker than your mouth. Mine, I can't get my brain to work fast enough.
Right.
He's like, if we had a child, you would obviously have to carry it to term, but they would look like Will.
Yeah. Down plan.
Yeah.
I didn't mean to outflag the host, by the way.
Is that a post-verdict new jacket, or is that one you had?
That was off the cuff.
This is not. You told me once I was dressing like a plaintiff's lawyer, right?
Oh, he's got cufflinks on. He is a plaintiff's lawyer.
He definitely gets Best Dressed Guest Award. Definitely an upgrade over our former.
Yeah, definitely an upgrade from when you were a defense lawyer wearing Velcro shoes and
Black Velcro shoes.
Just Dickies. It's a lot of Dickies pants.
Yeah, who bagged on the members only jacket? Was that Will did that?
It was.
No offense on that. All right, so we're going to talk news, and there's a lot because we haven't talked about it in a while. Bill, I want to start with you since we have a subject matter expert. Elon Musk deposition, you were involved. I think your colleague Mark actually took it, but
Mark took it. I just I ran support and watched the whole thing, and Elon was exactly what you'd think he would be.
And I think we talked about it afterwards, but his lawyer, who is not admitted to practice in the state of Texas and had not filed an application to.
He had filed an application, it just hadn't been granted. His name was Alex Spiro, and he's kind of a big Deal. I mean, Forbes came out with their first top 100 attorneys in the country. And there was 3, I believe, maybe 4 that were, featured, and Alex Spiro is one of them. And if you Google him, I mean, he's represented Jay-Z. I mean, he's got a huge, very impressive trial pedigree. But also on that list was Mark Bankston, my partner. And if there's one thing in this profession I can give advice to any lawyer, either side, don't piss off Mark Bankston. He is smarter than you, and God, he will write the most Shakespearean satire and emotion to make you look horrible to a judge. And Spiro accidentally, question 1 was, do you think he did anything wrong? And Alex Spiro not having a pro hoc, nobody showed up with him from Texas. So we have an out-of-state lawyer who's not pro hoc in taking it. And Mark was like, let me go ahead and remind you of the Texas Rules of Civil Procedure on deposition conduct. And, here's what your judging to be. And he just couldn't get it. And Mark read him case law. We were prepared for what we got, and it went pretty bad. So we had a hearing 2 weeks ago on the motion for sanctions for unauthorized practice of law by an unlicensed attorney, and also to defend the Texas Citizens Participation Act claims that they brought. It got suspended because there was just a lot to unwind there, and tomorrow at 9 a.m., we can go back at it.
Okay, Judge.
Ketzel.
Is it Travis County State Court?
Travis County State Court, District Court, and I can look it up.
I'm just curious. So y'all going to get her on everything going forward, or is there a risk?
No, but because it's a continuation, we get her again for this hearing to finish. But unfortunately, we're still on the central docket, and not like the Alex Jones cases where we got assigned, all the cases got assigned to the same judge, which was Judge Myra Garrett Gamble, who, again, I will for the rest of my career say she is a phenomenal judge.
So, yeah, people outside of Austin and San Antonio has it as well. It's called the central docket, where you don't know who is going to hear your motion until, is it the day you show up, or is it like who's going to show for?
It's morning of.
Yeah.
And you don't know who. Also, you don't know who's going to try your case.
Yeah.
You show up for trial, and you got to go to the central docket room and wait for the draw to see which courtroom you're going to, which is good and bad. I see the pros and cons to it. The cons, unfortunately for us, is we do like a lot of products liability or, 2, 3, 4 week trials. When you have that much and there was so much packed into a pretrial and you got all these rulings, and then all of a sudden you're in front of a different judge to try the case, it messes it a lot. But as far as moving your typical cases, I think the central docket is effective for what it does.
I don't want to commandeer your agenda, but one thing when y'all tried a case in front of her, I tried a death claim in front of her in
Gary Gamble?
November, and her allowing the jury to ask a question of the witness freaked me out.
So our practice is nationwide. A number of states, including Philadelphia, was where we learned about it, do that.
Okay.
I love it because you know where the jury's going as you're going, so you can mold your frame your case. If you have it framed wrong and you're losing, you can at least change. This isn't working. We can do something different.
Yeah, I didn't like it because if I chose not to ask something because my adversary didn't do it, I sat on it and I didn't try to get out in front of it. I didn't necessarily even get to prep a witness with my attitude and the mannerisms how I asked the question. And then she then allows the jurors to ask it. It's kind of cross your fingers. I mean, I literally sat there going, please get this right. I mean, I knew what the facts were, but it could have gone sideways.
At the same time, if you didn't ask it and they had it in their mind, as soon as they start deliberating, they're going to talk about it.
Yeah.
And typically, if they think you didn't ask it, because you wanted to hide it or whatever it was, then, it could go bad for you. I like it just because I know where I stand with a jury. I know if they're with me or I know if they're not. And so if they're not, I haven't had that problem yet. But if they weren't, I could change something at least to do something different because what I'm doing is not effective.
I was scared of it.
Yeah.
Okay.
It is very different and very new. So I've only had it in probably 4 or 5 trials now. But it's starting to catch on. I think you're going to see a lot more of it.
Okay, so back to the Musk case. So the deposition transcript has been posted on Huffington Post.
Well, it's public record.
Oh, yeah.
Yeah, so...
someone at Huffington Post has it up in a story, isn't it?
I believe the person that wrote it, his name's Sebastian Murdoch. Shout out to Sib.
So anyone can read it up there. And did they complain? Are any of the Musk sanctions against your law firm or your client arise out of that deposition finding its way on the internet?
No, they did a cross-listing for sanctions against Mark for apparently his conduct at the deposition. But unfortunately, Mark is very good at what he does, and he's the most researched person there is. So Mark is not doing something unless he knows he can do it. But yeah, unfortunately, so the deposition goes for 2 hours, the allotted time. There were a number of instances where Mr. Musk is instructed not to answer questions that, in my opinion, probably is not going to go well for him. And but you don't have a Texas attorney there, so the deposition ends, and then this non-Texas attorney goes, we're going to go ahead and mark this one as confidential. And Mark goes, yeah, that's not a thing. He's like, well, what do you mean? He's like, there's no protective order. He's like, but I said confidential. And he was like, yeah, that's not how this works. And he was like, well, I'm going to mark it as confidential. And then he just quickly logged off. So Mark then took and made his record properly that you can read on the transcript. And when we filed our motion for sanctions, the entire transcript was attached so that the judge could, judge, read for yourself how this non-Texas attorney acted without any Texas attorneys there, and you be the judge for it. So it was improper to an extent, but when you start dabbling in denying a pro hoc is a big deal, especially for an attorney like Spiro or an attorney like me that practices all over. Because if I get denied a pro hoc or my pro hoc gets pulled in any state for the next 10 years, every time I apply in a different state to get pro hoc in, I've got to disclose that. Mm-hmm. And defense lawyers love to throw it in your face. And so it really it can hinder your career to an extent if that happens to you. Luckily, somehow by the grace of whatever's watching over us, I have not had to push limits. I just never gotten into trouble to where I've had to disclose that moving forward. But it is a very big deal if you get in trouble with your pro hoc, because especially if you're an attorney that is home based in a state where you practice predominantly outside of.
I'm guessing our guests haven't had their pro hoc ever revoked or not granted. Just a guess.
Me? No.
Yeah.
Yet. Yet. Oh, by the way, you told your verdict story. You're on your way, Will. This is Texas is a stepping stone for you.
But why wouldn't someone just call you and say, it's pending? Do you have any objection to my attendance as lead counsel for the defendant?
They're probably sloppy. And there's case law, in fact, where a pro hoc pending attorney signed a plaintiff's pro hoc signed a pleading without it being granted, filed it, statute ran, and even though there was a Rule 11 agreement, that didn't matter. And the case law is very specific and actually penalizes you a lot. So if you're not in that state, there's no, who cares if your name's on the original petition or whatever it is? Like, just wait until you get your pro hoc granted and then do stuff. But I have a couple of times, based on agreement, shown up for deposition or done different things, always on agreement, do it on agreement. And we go ahead of time. They just didn't. And so when Spyro showed up, we were like, oh, where's everybody else? He was like, just me. We're like, oh, okay, well, we'll put this on the record. And we got one question and he decided to act the way that he did. And so we were like, all right, that's how it's going to go.
So the lesson is be cool.
Work
with your fellow counsel, reach agreements.
If you're in a case, just be like, what would Bill do? And do the opposite of that. Because there is nothing pleasant about working against me.
I still understand this isn't a guy selling white walls in the corner. He's got enough money to hire.
Oh, I mean, he's a partner at...
No, quit. You're talking about Elon.
Oh, I was going to say...
afford the rate to have a few people show up.
Oh, don't get me wrong. It's Quinn Emanuel. Their local is in Austin. It's John Bash, former special counsel to the White House. Like, I mean, there's, he had shown up and argued the Texas Citizens Participation Act hearing. And so we'd been in front of him. But he argued to defend whether or not we should get Elon's deposition, which he lost. They had Texas counsel, there's no doubt. And it's Quinn Emanuel. It's not a small firm. But Spiro's the guy, and he, I guess, usually gets away with it. And unfortunately for him, he talks shit to Mark Bankston. And again, any plaintiff side or defense side, it doesn't matter. Just don't mess with Mark. That's all I'm just saying. For me, it's more fun when you do, because I get to watch, and he's creative on how he's going to do it to you.
Well, we'll see what happens tomorrow. Next, I wanted to go into... And Bill, you'll report back, I'm sure, right?
Oh, 100%.
Next to the Astroworld. So the Astroworld cases from the Travis Scott event, that was a hot topic, I think, before we started this podcast. So we never really...
Still is.
Yeah, we didn't really get into it. But now it's back in the news because presiding judge over the MDL, Kristen Hawkins, has denied Travis Scott's motion for summary judgment.
Granted Drake's,
but not Apple and the Travis Scott production company. So I think the first trial was set
for like 3 weeks.
May. As we were coming on air, I looked on Google, and it looks like Apple's going to try to appeal it and get a mandamus, and they're trying to say it stayed the first trial.
I still don't know what they're appealing. Did you?
It said their motion to dismiss. It was all behind.
That's not appealable.
Right. It would be a summary judgment.
It would then you have to go to summary judgment. Then you got to go to directed verdict. Then you get a verdict against you and you can appeal. I think that wouldn't be right.
Unless they had a 91A
or discovery rules.
I don't think 91A is interlocutory.
Yeah.
Unless the plaintiff loses and then the case is dismissed.
So Will was involved in it when he was on his defense side, but I think your client basically got out or something happened.
My client employed one of the show director types, Emily Ondokin. It's also part of the 6 people that were considered to have charges brought against her. She was not, but none of the 6 were. But yeah, so I had a company called BWG that has, because of a limited pool of insurance, has resolved a few cases, has been dismissed from a few cases, but now pending without the benefit of insurance and a lawyer getting paid, still defending a few. But I'm efforting with liaison counsel to try to find an exit.
And who do you know this first trial? Is it on certain issues or if it's certain plaintiffs?
My understanding it is the Arnold Aitken family, the Dubisky family.
Correct.
I believe is that first group, and I think it's just that one.
Yeah, that single death.
Beneficiaries. Yeah.
It's it's a number of beneficiaries on one solo death.
Yeah.
My understanding is the reason, because you got tens of thousands of claims in this MDL, and typically your judge would say, give me, your bellwethers would be your first couple bellwethers would be your run of the mill, what's your average case. But here, I think the reasoning is, one, it's Jason Aitken, so who's not, the jurors don't tell him no, judges aren't going to either. And two, it looks like the way they framed it was, the deaths in these families deserve the justice now. There's no reason for them to keep waiting. And so I think that's why that they got slotted, because it's not the entire bellwether system is all, I think, pretty big cases.
I think the motivation too was the death claims from a discovery standpoint on the damage side were non-existent really. It was more of a liability case that was across the entire platform.
I think it was just like, who is liable?
And it's when you had the TBIs and the ortho injuries and the middle language claims in mass, they knew that those kind of had to wait. And what she wasn't going to do was allow discovery to hold up a trial setting as real. So when she said, I think the next batch might be another death claim, and then there's a slew of PI claims. I think that's how it's staggered. And I don't know.
But I think she stacked them like every 8 weeks or 9 weeks, something like that. So they're well, if it's as long as there's no stay that doesn't get lifted, I mean, these things are going to start moving.
Well, the question is going to be, is Jason going to have the same success against, like he does with Bear? He goes and has Monsanto cases. It seems like every 6 weeks, wallows him, has another one, wallows him.
It ain't just them. When we hit our $976 million, the actual damages was $176 million in Philadelphia. That was on a Monday. The Friday before, Jason hit some random defendant for $175 million. I was like, I don't know. I've seen him a couple times, and it really is. I mean, there's a couple of attorneys that I've seen where I'm like, him, Mark Lanier, there's a couple that I'm like, I don't even have that gear. I'm pretty good at this. I can't do that.
I can imagine.
They are just that good at what they do, and so hats off.
If that's a true bellwether from a spirit of wanting to hang around. Is this going to, Live Nation, Apple, the facility, is that going to be a jury finding that's motivating to get rid of the whole thing?
When you're on the other side, you take off your plaintiff's hat, because now you have to do that. Put on your solid navy with gold button jacket,
black socks and brown.
When you have somebody like Jason or some big name that is very effective on the other side of you, especially in a case like that, don't you just want to be like, hey, let me pay them a premium to get out of the way so that I can try to figure out how to save some money on the back end, because it ain't going to be against him.
No, and Pete knows this. I had a letterhead rule. We paid a VIG on the letterhead, a different percentage based on who was going to be standing in front of a jury. I just say, and again, I wouldn't dream to speak for that firm. They're good at what they do. I think they want to get to court in that case. And I tend to think that Live Nation's not going to want to continue going to court in that case repeatedly against other lawyers.
Should I put my photo on my letterhead?
Should.
2 thumbs up.
But I'd pay Wes. I wouldn't pay Kyle. So that's what.
That's the scariest thing. Kyle's the one that Wes is the angry one. Yeah. Kyle's the one that's like, I'm going to let you hang yourself, but you're not even going to know that you did it. Like, I mean, my partners are hilariously talented in some of the best ways.
If that thing gets stayed, that's a real outcome.
There's no way it can get stayed for that long. You've literally got 50, 60, 70,000 claimants. Yeah. Like, it's big.
Well, the appellate court can make that call too, right? And they've got their eyes on it.
I think so, yeah.
Okay, I've got a bunch of stories. A lot of them, I say silly, but obviously someone was hurt or something, but they're not, I don't know how much legal, like...
Fascinating people.
Usually I have some angle where I'm like, that brings up a good point. Herrick, what do you think about whatever, tort reform?
You asked us a story about a dog chew toy that was in the shape of a poop.
That was good.
Jack Daniels bottle. So there was, you've already strayed away from this, scheme that you've just described.
Some of these are kind of, I would say, not as serious as others. Okay. Did y'all see the class action lawsuit filed against Cinemark Cinemas for
give me my $2
shortage for a $9 beer? Anyone see that?
I did. And I know, who's going to get paid on that?
Who?
The lawyers. That's it. Everybody else is going to get their $1.90 in 6 years. And that's unfortunate.
For, 2 ounces of beer.
If they're going to bought a beer at a Cinemark?
Yeah. First of all, the class action is exposing alcoholism.
I would be part of the class.
It's like, I got to go to a movie. I can't go 2 hours.
I mean, before Draft House and the lounge chair movies.
Yeah, this is a Cinemark. There's no reclining there, I don't think.
No, I would not feel compelled to order a beer.
Yeah, maybe at like an Alamo Draft House. I think I've had one.
Sure, that's better. They better give me my 2 ounces back.
Yeah.
Yeah, but if you're slamming $9 beers at Cinemark to watch what Toy Story with your kids, probably got some issues.
I thought you were gonna say Forrest Gump.
Yeah.
Which is still to this day one of the most offensive movies of all time.
Yeah,
It's also Pete's favorite.
yes, it's one. Bill is
He brought up Forrest Gump, I don't know, a year ago.
Yeah.
On a random episode, and I was like, "Wait, are you talking about the movie where the woman with AIDS and drug addiction sexually assaults a special needs person for 2 or 3 decades, and then leaves him to raise a child that she birthed before dying?" And Pete was like, "Well, when you put it like that," so then Halloween came.
Story of America.
Yeah. He's like, "You left out the part where he ran tailback for Alabama."
Yeah.
I saw the English patient in a theater. I would have drank heavily.
Oh yeah,
That was a down.
or something.
Absolutely. English patient.
Yeah, that was a tough one. That was a long time ago, though. You're dating yourself
That would have been 8.
Do we know if the appeal landed in the 1st or the 14th?
on the Astroworld. No, I haven't looked yet.
right.
I mean, this is breaking news. It won't be breaking by the time this airs, but. Okay, here's another one with your friend Alex Spiro, representing his client Megan the Stallion.
The Stallion.
She's being sued again. We've talked about other litigation against her. One of her former, I think, security guards, Emilio Garcia, said that after a night, this according to the Associated Press, Emilio Garcia said that after a night out in 22 in Ibiza, Spain, he was in an SUV with Miss Stallion when she began having sex with another woman right next to him.
God, that poor soul.
He was unable to get out of the car, and that would have been a bad idea anyway because he'd been in the middle of nowhere. He was embarrassed, mortified, and offended throughout the whole ordeal.
Was he fired before he filed this lawsuit?
After so he says that's sexual harassment, and then she fat shamed him. That's kind of a common theme.
Yeah, what's up with Houston female entertainers and fat shaming? Lizzo started it, and now we got this.
I don't know.
Well, allegedly Lizzo. I don't know. We need to do a follow up on the Lizzo because the banana thing. That's weird.
Yeah.
Remember Kyle brought bananas and you got real
God.
awkward.
That was before we had Amanda.
Yeah, we did not have our canceler.
Yeah, I don't know if is that sexual harassment to engage in a
If you are in a car with your boss and that boss starts having sex with another human in front of you, I feel it's a little harassment.
I mean,
I love that Peter Files being
Pete, Pete, I hate to say this. The 80s are gone. All right? They're over. They're gone.
And
even the 90s.
Yeah, if I remember they did that and it was okay. So I don't know what you're talking about.
No, sorry I ruined your Black Panther party.
But Alex Spiro is representing her, and guess what he says? This is an employment claim for money with no sexual harassment claim filed and with salacious accusations to attempt to embarrass her. Kind of like what y'all heard from him on your case, right?
Yeah. He's a little
comment on that news story.
Alex Spiro sure is sounding like Alex Spiro.
All right, another one, and this is for y'all again. Mr. Bankston sued Fox News, Newsmax, and others.
Oh, yes.
What was the story there, Bill? What happened?
I actually, I can't talk a lot about this case, but
we can talk.
We have a very mutual friend, you and I, on the other side.
Oh, okay.
Unfortunately, we weren't able to resolve the case, one of the defendant's cases beforehand, and I haven't spoken with the 2 lawyers that are working on that with me yet, and so I don't know how much we want to put out in the press.
Okay. Well, the story was, and it's this is public, and you don't have to comment on it, but that another person was misidentified as being identified with the Allen shooting.
Yeah, Allen shootings, correct.
By a lot of different people, and so we talked about this, I think, a couple of times ago. Look, sometimes newspapers make mistakes, right? It happened, actually, I don't know if you heard this one, but my son, they used a picture of him in the New York Times when they're talking about NIL because he has the same number as Arch Manning. So they wanted to, it said, pictured here, Arch Manning. He was actually my son. Okay, the next day they put out a retraction. That was some other kid and not Arch Manning. That happens. So this case, did they make a mistake and they have an opportunity to rectify it?
Oh, they definitely had opportunities.
Oh, okay.
It's purely on the letters we signed.
Oh, okay.
You have to,
so
especially when you're talking about publications, like true journalism. There's statutes that broadcasting statutes that protects.
Okay.
Here, and I will say there are more than one news outlets that did not retract in time, saw the wrong that they did, and are no longer in the case. The ones that are still there are the ones that chose a different path, I guess. I don't know.
Okay.
In my opinion, maybe.
Case is pending in where?
Harris County.
All right.
And are you saying that just from my own standpoint, is this a TCPA case?
It's a defamation case. We will face the TCPA. They haven't filed it yet, though.
And then do you send the letter out and ask for a retraction and wait the 30 days?
No, you're right. We send the retraction letter out before we file.
Right. And the parties that have chosen to retract, those are the ones that...
Nobody chose to retract on timely. And at that point, some of them, Google the plaintiff's lawyers and realize we fucking around. So they pay us to go away.
You two can have a documentary about you.
Yeah. Yeah. Hey, we got HBO on speed dial now. You can thank Mr. Alex Jones for that one.
How'd you get venue?
Against Alex Jones?
No, here in Harris County for that.
The place of residence for the plaintiffs and the mass production of dissemination of the facts.
Okay, here's another legal one. Remember that story where the young girl was at the pool DoubleTree around here and she got sucked into a drain pipe and died?
Richard Nava's got that case.
Yeah.
And their answer is offensive as shit.
Okay, so the defendant filed the answer that specifically pled the mom was at fault.
Yeah, you're bad parents.
Illegal words.
You're bad parents for letting your 8-year-old get sucked into this thing that shouldn't have been on.
Yeah. So the question, and this is really for Will mostly, how do you walk that line? Because you have to plead your affirmative defenses, right? But you don't have to plead them right when the news is looking to see what you're going to plead. You can wait like 2 years or...
Yeah, general denial that and go away.
Agreed. Don't, because the precision of that, someone's going to come in, an excess lawyer's going to come in and say, what in the hell are you doing? And they're going to want to clean it up. And they're going to have an amended answer. And a good plaintiff's lawyer is going to say, wonderful, but that's a prior inconsistent statement. Yep. Or it's not a judicial admission, but it's still an admission that you took as a corporation. And they're going to put it as big as they can put it.
Does it not count as a judicial admission if it's corporation?
If it's vacated, it doesn't. It's superseded, it won't, but it still comes in via a
prior inconsistent statement, yes. Okay.
Yeah.
So if you were crossing the corporate rep, you would say, this is what you filed, and here's the answer.
Remember when you blamed the parents?
You're blaming the mom? Is that what you're doing? And then they got to decide... Then, all right, what are we doing here? Are we going to blame the mom or are we not?
It's actually hire someone like Amanda to come in and say, let's clean this up. Let's find almost at that point counseling on how we can send a message in the litigation that acknowledges we screwed up. And if the lawyer's got to fall on their sword and say we screwed up, fine. But there's got to be something there where that can't be there. But, I mean, there's a way, one, don't plead with that precision. Just say, Chapter 33. Chapter 33 is going to put... responsible third parties, comparative fault.
All of it.
Just leave it at Chapter 33. And if there's something after you mock trial, after you do jury research, and after you tested that mom is meaningfully comparative, maybe. But you're not going to get her joint several, so what's the matter? All you do is if you can't get her 51, it doesn't matter. And I actually had a case, a Brownsville drowning case, where it was blame the mom, and we kind of talked ourselves out of it. And someone mentioned that you got a big parental immunity problem in that. Whether you can, is it a Chapter 33 RTP, or is she a claimant by definition because she's obviously got her own claims for the injury to the kid as a bystander?
Consortium.
It's a mess. So the easy answer is try it straight up and down on liability and not go down that road. If you can't get joint several, don't submit them at all anyway.
I really hope that Richard, I'll see if Richard will come on and talk about that case. He's a plaintiff's lawyer on it. And my understanding is the parents went to the hotel and begged them for hours to let them review the security footage, and they were like, "Nope."
Oh wow!
Because they couldn't find. I mean, I think it started happening. Hours went by, they couldn't find her. Equistar or Equisurge came in. They're the ones that found her sucked into this giant tube, and they refused to let the parents look at the surveillance footage. So I genuinely hope that there is not a settlement in that, and that family is about to own an entire, a few hotels.
Well, if they got a big enough tower, that's going to be a Walt Disney alligator event. You won't hear it again. It'll be gone.
Yeah, you wave $100 million at that and make it pray that it goes away.
Hire crisis management to defend the answers you filed.
No, honestly, no. I mean, that's when you know you've done something wrong. When your first move is you're in crisis management already. You had one job, general denial. You didn't have to say anything else.
Yeah. Or the burdens of a defense lawyer with an associate that probably didn't know any better, and someone said, e-file it, and their name's on it, probably never read it.
It's like, hey, that's why partners should proofread.
Well, not to get on the Dallas thing. It was a Dallas lawyer. I can't remember.
Of course it was. I heard it wasn't. As soon as I read it, I was like, this guy definitely leases a 3 Series BMW.
Or gal. As a Dallas
guy or girl, you're right. Correct. Thank you, Pete. It's not the 80s anymore. You're learning.
Yeah. Speaking of Dallas, there's a lawsuit alleging 2 women employed by a Highland Park Village boutique have filed a lawsuit against a store security guard and his alleged employer. These people like alleged, claiming that they were secretly videotaped by the guard while in a private restroom. Okay, couple questions.
Alleged is because of me.
Yeah. Oh, yeah.
Yeah.
How's the claim against the employer for this guy doing something outside the course and scope of his employment, i.e. filming people, unless maybe he thought they were stealing stuff?
Because I guarantee you part of his job was to also review cameras filming people that they didn't know about, just not in bathrooms like a creep.
Think it's covered, Will? Covered claim?
Yeah, he's covered. Whether it's any good is a different question.
Yeah, what are the damages?
Yeah.
If he's being prosecuted.
Was it a bathroom or changing room? Something?
Yeah. So they didn't know about it. Now they know about it after the fact. But yeah, what are obviously mental anguish.
Yes, negligent supervision. Throw it up there. Let's see what the jury does.
Yeah, for your liability.
Yeah, who knows? They'll plead a negligent hiring claim too, I'm sure. He's got some background proclivities that should have been apparent at the hiring stage just to get a pleading on file.
Proclivities. Now you're sounding like a defense lawyer again.
Yeah, but they're going to bail on the course because they're going to say he left the service of the company by doing that. The security guard that picks a fight in the parking lot that's not further in the business of the master. That line of cases, which probably should find a better term to use. That's getting a little antiquated now.
Yeah, it's not the 80s anymore. Will
That's the case.
It's just like a going thing here.
Cases.
So you've got possible coverage, insurance coverage concern.
Is it a reservation of rights issue, or you think they just go own it and say we got to defend?
It's going to cover the company. It's going to cover their employee. If he's outside the course and scope, I think the question then it's not an insurance issue. It's the defense lawyer has a conflict to represent both, and they probably need to split the file, have someone represent him directly, the company directly. The company needs to fight for summary judgment outside the course and scope and let him go to the gallows on his own.
Yeah. All right. Did y'all hear about this case that Brant Stogner filed for the child injured in a religious branding ceremony?
Yeah, that was a crazy set of facts.
You didn't see that one? He says his father says his 11-year-old son was branded as part of a religious ceremony. He's suing a Hindu temple. They left scars of the Hindu god through a branding ceremony.
He's Buddha, right?
There's really not much to talk about there other than, I don't know. Well, is there religious? We talked about in our last one, religious.
That will not be covered.
Yeah. For religious immunity too. They're charitable?
I was thinking there's something on the CPRC that protects religious organizations.
It does, but branding a child, Brand is a smart guy, and Jennifer, his wife, also works with him. She's super smart as well. So there's no way they didn't do their research before filing a case like this. So they've got to have an angle here. I've just never run into a set of facts where I'd needed to learn this angle. But you are right. There is 100% a religious, not immunity, but what's the word I'm looking for? Yeah, kind of immunity.
Yeah. Charitable. It's a charitable immunity. There's a cap. You can bust the cap with gross.
You can bust the cap with gross.
Yeah. So if whether it's a Hindu temple or the YMCA, you can be branded if your parents are okay with it.
Along those lines, a family, Lake Travis, sued Lake Travis School District superintendent, athletic director, after a group of football players put peanuts in an allergic teammate's locker. He was allergic to peanuts to some football players. It came up because one of the football players was like a UT recruit or play recruiting.
It is a messed up story.
Yeah.
Like this isn't just like, hey, I thought it would be funny. I mean, there were bullying issues that had already been disclosed in the school way before this. They did a Title IX investigation, according to them, and we're like, oh no, everything's all great. And I mean, they literally almost killed this guy. And it wasn't just one instance. Apparently, I saw the news story where it was multiple instances where they were putting peanut stuff in his football locker room and stuff. But apparently they had rubbed peanuts all over his, pads or something and put them on. And I mean, this kid went anaphylaxis. It's
sick.
It was, and and I get that kids are dumb. When all of us have been 16, and unfortunately, when I was 18 and went as a freshman in college, we got Facebook. We were one of the first schools in Texas. Nobody told us how to do this. Nobody told us what to put on social media. And some of the stuff that this kid put out there is horrifically way worse for him. I assume he comes
The bully?
Yeah.
Wow.
The bully is there was zero, he was not apologetic. In fact, he laughed about it and made jokes about it after the kid almost died, even put him in the hospital. So uphill battle, I assume the kid probably comes from a little bit of means, which is why there's a lawsuit involved. But also the school, for them to do the investigation with what they had and come out the way they did, they got some issues.
Because they didn't discipline the bad actor at all?
They found no wrongdoing. Not just that there was wrongdoing and here's a slap on the wrist. They didn't find any.
Where's this at?
Lake Travis.
Yeah.
Almost as bad as Westlake.
And here's a question for you. How would homeowners policy kick in on the son, or
if they sue
the minor? Yeah. He's like 17.
why would the homeowners policy not kick in if you plead negligence?
Well, it might provide a duty to defend if he's an insured as a minor in the home, but they're going to...
Like an intentional act.
They're going to deny it all day, every day on an intentional act.
Yeah, look at decent lawyers depending on who their carrier is.
Because there's no negligent parenting, thank God. That's not a cause of action.
Mine's 9, so I don't have to worry about it yet. I'm still asking everybody what their favorite dinosaur is.
All right, remember we talked about the lawsuit involving Pop Isaacs, the Texas Tech basketball player accused of sexually assaulting a 17-year-old girl during a team trip to the Bahamas.
Yeah, and then that all went away? Is that
went away, but it looks like it was a dismissal with prejudice. For the folks at home, anytime someone dismisses a lawsuit with prejudice, you can guess it was settled.
Allegedly, in Pete's opinion, for defamation purposes.
Yeah. So it appears that there was a settlement. And there was there's also a kind of an agreed statement. That's also.
It does say that there was settlement. I didn't see.
It didn't say settlement, but there's an agreed kind of language for a statement.
Which nobody is admitting wrongdoing.
Yeah.
The events are unfortunate, and we just hope everybody can move past it.
Yeah, the parties of the lawsuit and the Title IX complaint have been. Everyone's agreed to dismiss all claims that have been or could have been alleged as against one another.
So does that mean Tech paid on that?
Someone did.
Tech couldn't have paid. It's a state school, so it would have been.
Oh, they'd have to go through. Yeah.
Yeah, you couldn't. It could not have been confidential. So it had to have been parents or boosters or somebody.
Well, in any event, the guy Pop Isaacs loved his time at Tech, but he is in the transfer.
Hey, he is, but I mean, when you think about it, there had to have been a little bit more to the story that we don't know.
Because remember, the Title IX stuff was that they brought in the donors,
boosters
in to lay in us, and they're buying all the booze, and then it ended up being a drunken thing where it was. I guess I don't know if it was arguable that it was consensual. It's just she didn't have the age, or she didn't have the men.
No, she has the age. 17.
She didn't have the mens rea to.
I think it was intoxication that did it. Yeah. But it ruined that kid's career.
Yeah,
whether or not it was deserved, I don't know. There's obviously facts that we'll never know.
They took a lot of heat for letting him continue to play even after this had all come about.
Hey, he did average 16 points a game, though.
Rusty Hardin is suing Houston Area Church and the Southern Baptist Convention for a bunch of victims of a serial predator.
Yeah, it's like apparently they saw them. They were like, hey, the Catholic Church seemed to come out all right on this.
Yeah.
So, because it was like a systemic move them around chess pieces of sexual assaulters of minors, right?
Yeah. I just thought it was interesting. I mean, I'm touching a third rail, but Rusty, defended all the Deshaun Watson victims. And of course, all those, well, Tony's clients, according to Rusty, were all a bunch of lying money grabbers. And so, I guess these ones apparently aren't. So, but like I said, I touched
Hers and yours.
Touched the third rail. His are definitely younger people, and they, unlike Mr. Watson, I think the culprit here has been criminally prosecuted, so that's a little different.
And I don't think anybody is a masseuse.
Yeah, true. Houston Appellate Court dismisses defamation lawsuit against prominent lawyer Bud Frazier. So that case, the Chronicle.
Him with fees too, right?
Yeah. Well, so it was sold that Wesley Ward was the judge that had denied their slap motion. So
I'm surprised slap the TCPA was around back.
Yeah. So he sued them for defamation for something they said about. It's coming back to roost. It was a 2018 story that examined concerns, claims that hospital investigation found that Dr. Frazier and his team implanted experimental heart pumps in patients who did not meet medical criteria to be included in clinical trials. So we're monitoring this, Memorial Hermann thing that we talked about in the last one. So he sued them. They filed a motion, a slap motion, TCPA motion. Wesley Ward denied it, and it went up on appeal, and finally that decision was reversed, and I think fees are mandatory.
Reversing, yeah.
Yeah. So it'll be remanded to the trial court for determination of fees.
Wait, who's the winner after it was all said and done?
The Chronicle and ProPublica. The media. Represented by Laura Prather and Catherine Robb of Haynes & Boone, who represent a lot of media companies.
I welcome them.
I thought defamation was not a thing.
Me too.
It was like
4 years ago
class, and then I met Bill, and apparently
this is real.
It's a thing. It is a thing.
All you want. If it hurts, I'm in.
All right. Did y'all see any other stories? There's a couple others that I think we can probably pass on. I think we covered the big ones. Y'all have any that you saw that you liked?
Trump fell asleep during trial. That's kind of cool. And then a guy lit himself on fire outside. That was I didn't expect that.
Well, and Trump was sanctioned $9,000 for violating gag order.
Yep. And gag is a fun word. You know that, Pete. So, but also, I'm going to go ahead and just tell the world, right? I bought a Trump Bible. Best $59.99 I've ever spent. Why? He's selling Bibles with Glenn, his buddy, to raise money to defend him for his legal troubles that he's getting into for misappropriating the transfer of funds to pay off an adult film star who he paid to have sex with him as his wife was in bed recovering from birthing their last child, Barron, 2 days later, or 2 days before. When else are we going to be able to buy that Bible?
Well, when you're sad,
I mean, tell me that's not one, it's an outlier Bible, right?
You could have built out some Lee Greenwood, and you don't want to Google the lyrics. You can go to your Trump Bible and read them.
And when you're done, you can turn around and you can read the Declaration of Independence. So I've got them all. It's going to go in a shadow box and get hung on my wall so that my son never forgets why I bought that Bible. But, bought that Bible. Other than that, I don't have any other legal news, Pete.
All right. Well, very good. Well, thank you to our guests for joining us. Will, is your website up now that you're a verdict obtaining plaintiff lawyer?
You got a couple of commas in those verdicts now?
Not up yet.
Okay.
I have posed for my photographs, so our website will be imminent.
Did you go blue steel? Did you go smile?
I went, trying to get plaintiff's lawyer frown. I'm not good at that yet, but I did.
I'm going to be the first Google review. I'm going to be totally airbrushed.
Exactly.
No way that's him.
Exactly.
Yeah, whoever did your photos, did they give you some options? Do you want to do the, that one, or do you want to do the nice one?
I kind of demanded it in between. I didn't want to be smiley. I was a little smiley in my other picture. It was too smiley. I got a website now. It's just a stub.
So it's like
an old picture. It was teethy smiley. It was
teethy. Okay.
Yearbook smiley. So I'm not yearbook smiley.
For your Thompson Cohen or the one
Thompson Cohen.
Okay.
I did change mine because mine was sitting down, kind of like this, leaning up, And multiple people met me and were like, wow, I thought you were like 5'7". I was like, what? And they were like, I also thought you were Jewish. I was like, wait, what? And then I looked back at my photo. I was like, yeah, I kind of see it. So I had to change it up so everybody knew that I was slightly taller than
It's going up.
Tie or no tie?
I did both.
Okay.
Hop sack blazer with no tie, and then a pinstripe with tie. Went lawyer, non-lawyer, so all of it.
Okay.
Yeah.
It's like I'm watching and like this show has reared you into being a plaintiff's lawyer.
So what's the website URL?
Moyefirm.com.
MOYEFIRM.
Wait, I have a quick question before we wrap up. It's Moye, not Moye?
It is Moye.
Moye.
Oh, correct.
Moye.
Yeah.
It's like Moet.
Judge Eric Moye in Dallas put the accent grave over his E.
Moye.
He being from Bridge City, there are no accent graves in Bridge City. So
There were until someone beat it out of whoever first tried it.
every lawyer who's practiced for any meaningful time that knows Judge Moye believes it's the same pronunciation.
That's what I always said because it's spelled the same.
Times a boy.
Moye.
Yeah.
All right.
All right. You can find Herrick at SOVANY law.com.
That's right.
Okay. For all your probate, commercial litigation, medical malpractice, maybe.
100%. Wait, yeah. You said you sent it all to him.
Oh, yeah. Security.
Yeah. He taught, I do med mal, quote unquote, and I was like, learn something. I was like, wait,
There's a
what?
difference between being good at it and there's need to really do it.
Yeah, thanks, Pete.
But he's both good at it and he'd like to do it.
I agree with you.
You're the right guy.
Yeah.
So,
Thank you for teaching me.
you can find Bill at, is it fbtrial.com?
F as in Frank, B as in Boyd, trial.com. I'm the tall looking one in my photo.
Yeah. Now you are. I'm at Coma Mediation, Amanda Orr Strategy Group, Josh Felon, Chaos Theory.digital. That's where you can find us all. Thanks, everyone, for joining us. Thanks, guests, for joining us.
Thanks for having us.
And we'll call it a good night.
That was a little.